I'll call to order the Subcommittee on Communications and Technology and open our hearing on improving FCC process reform. The communications industry is one of the few sectors still firing on all cylinders in this economy, averaging $80 billion a year in investment since 1996. It cannot continue to do so, however, if faced with poor FCC process. As Blair Levin, a previous FCC chief of staff and architect of the National Broadband Plan, has lamented, and I quote, "The FCC is becoming more of a political institution and less an expert agency," close quote. Former Chairman Janikowski did make progress in reforming the Commission, but there's more to do. The agency has fallen short in the past under both Democratic and Republican administrations. Without codification of certain protections, it will undoubtedly do so again. Only statute can ensure good process from the Commission to the next Commission. That's why we're discussing two draft bills today designed to minimize the potential for procedural failings, to curb abuse, and to improve agency decision-making. The FCC Process Reform Act passed the House as H.R. 3309 in the last Congress on a 247 to 174 bipartisan vote. Contrary to the assertions of some, it does not change the public interest test, nor strip the FCC's authority to protect consumers and competition. It merely asks the agency to do what we ask of most grade school students: show your work, to publish the specific language of proposed rules, to identify a market failure or actual consumer harm, and conduct a cost-benefit analysis before regulating, to give commissioners, parties, and the public an adequate opportunity to review proposed rules, to publish the text of decisions promptly and examine whether adopted rules are meeting their purpose, to set shot clocks, to give parties and the public more confidence that the agency is acting with dispatch. As Commissioner Pai put it in his recent statement on the SoftBank Sprint Clearwire transaction, many of these ideas can be found in President Obama's 2011 executive order on improving regulation and regulatory review, which binds executive branch agencies, but unfortunately not the FCC. And remember that in many states, public utility commissions already operate under much of what's proposed in this legislation. This is not unusual in America, but it is in Washington. The draft bill also requires any transaction conditions to be narrowly tailored to transaction-specific harms and otherwise within the FCC's jurisdiction. This was in the bill before Mr. Wheeler was nominated as FCC chairman, but his blog about AT&T and T-Mobile merger reinforces the need. In it, he notes that the Communications Act does not currently prohibit the FCC from, and I quote, imposing merger terms and spectrum auction rules that might seem to be regulation in another guise, close quote. This is precisely what the transaction review process should not be used for: backdoor rulemaking. Despite what you may hear, the bill does not dictate the outcome of a transaction review, nor alter the public interest standard. The FCC can still find a proposed merger to be inconsistent and against the public interest, and it can deny that transaction or adopt tailored conditions to remedy the specific condition. Now, some opponents will argue implementing this bill would be difficult and will lead to litigation. Well, that's not true either. Most of the provisions rely on established definitions and accepted concepts under the Communications Act, the APA, and other law. And rather than micromanage the agency, the bill largely establishes principles and gives the FCC flexibility on how to implement them. I'd nonetheless be happy to work with anyone who has a good faith interest in improving the language, as we did leading up to the final version of the bill that passed the House. Others say it would be unwise to apply these types of reforms except government-wide in the context of the Administrative Procedures Act. Well, that'd be fine with me, but this committee doesn't have that jurisdiction over the whole APA, and we need to start somewhere in Washington to reform government. Since the FCC oversees a huge and growing part of the economy, it seems a worthy candidate to commence the discussion. Now, the second draft bill, the FCC Consolidated Reporting Act, passed the House as H.R. 3310 last Congress by voice vote. The legislation looks to relieve burdens on the agency and make its reports more meaningful. It does so by consolidating 8 statutorily mandated reports into one biennial review and eliminates 12 outdated studies like the one on the telegraph industry. The existing reports are cumbersome and often unnecessary, and a recent Government Accountability Office study on the video competition report, for example, concluded the reports may not be needed on an annual basis, quote, especially given demand on FCC staff time for other monitoring and regulatory duties. The proposed consolidated report will help break down siloed thinking and present a more useful picture of the marketplace upon which to base policy and judgments. Now, I know there are some that have said there's no reason for this committee to spend its time on these efforts, and why would we take up these issues again when the Senate probably won't agree? We're here to reform government. We're here to make changes. We're not here to defend the status quo. And if the United States Senate wants to continue to have the Federal Communications Commission do its telegraph report, well, fine with them. But that's not what we're about. The last thing we want to do is stifle an industry that's continually growing and innovating. Yet that's exactly what could happen if the FCC is not held to certain standards of decision making. The industry deserves an efficient and effective regulator we can truly call expert, just as the public deserves a transparent and accountable federal government, and these reforms are a good place to start. With that, I would yield back the balance of my overused time and recognize my friend from California, Ms. Eshoo, for an opening statement.
Thank you, Mr. Chairman, and good morning to you, and welcome to all of the witnesses. Former Commissioner McDowell, it's always a pleasure to see you and have you with us. Just 2 weeks ago, Mr. Chairman, we had bipartisan consensus on the need to focus on how federal agencies use spectrum. Today, we're returning to legislation that this subcommittee has debated for 3 straight years. It hasn't, nor in my opinion, will it go anywhere. Administrative law experts tell us it would tie the FCC up in years of litigation, and I think it really contains some policies that are not good policies. This proposed process reform, in my view, is a backdoor way of gutting the FCC's, some of the FCC's very important authorities. Congress created the FCC to safeguard the public interest. Big corporations, as we know, are well equipped to advance their private interests, and they have every right to do so. But consumers need advocates, and competitors and innovators need a referee to level the playing field. As we all know, the FCC faces an enormous set of challenges in the coming years, including the upcoming voluntary spectrum auction, the transition to IP, and the modernization of the E-rate program in our nation's schools and libraries. Our role at the subcommittee, I think, should be to ensure that the agency is equipped with the tools to meet these challenges while ensuring that the FCC can continue to protect the public interest and preserve competition. I'm going to repeat that, preserve competition in the communications marketplace. If we really want to accomplish meaningful reform, I think we should start with a proposal that enjoys nearly universal support, including that of the acting chairwoman of the FCC, Commissioners Pai and Rosenworcel, and former FCC Commissioners Abernathy, Copps, and McDowell. The FCC Collaboration Act of 2013, H.R. 539, is bipartisan, it's bicameral, and it will allow FCC commissioners to more easily collaborate with one another outside of public meetings. As the FCC increasingly responds to complex, highly technical issues, I think now is the time to get this legislation passed and signed into law. We just shouldn't delay it anymore. It's really a source of embarrassment. Everyone is for it. We can get it done. Secondly, I support allowing commissioners to appoint the electrical engineer or computer scientist to their staff that some of them have asked for. This is a bipartisan proposal offered in the last Congress by former Representative Stearns. Third, I support the creation of an online searchable database of consumer complaints, an idea advanced by the ranking member of the full committee, Mr. Waxman, in the previous Congress. And finally, I agree that there could be opportunities to streamline many of the reporting requirements that Congress has placed on the FCC. We're now in the 7th month of the 113th Congress, but only one bill has moved through our subcommittee. Instead of working on legislation that creates billable hours for Washington telecom lawyers, I think that we need to work together to craft policies that are actually going to move, that will create jobs for innovators, promote investment in infrastructure across our country, and technological advances that will help American families. So I thank each of our witnesses that are here today. I know that we tried to get some of the opposite sex to show up. I know that they are alive and well out there, but for one reason or another they couldn't. But I want, if the public is listening in, not to think that we have overlooked that. And again, I want to thank you for working with our subcommittee to help drive competition, promote innovation, and protect consumers. And with that, I will yield back the balance of my time, Mr. Chairman.
Thank you, gentlelady. And I'm going to ask for a moment of personal privilege now to acknowledge the service of our committee chief counsel, Neil Freed, who will be leaving the subcommittee soon to work for the Motion Picture Association of America. Neil has rendered outstanding service to this subcommittee for 10 years. He served as subcommittee counsel under full committee chairman Towson, Barton, and Upton, and subcommittee chairman Upton, Stearns, and myself. He's been part of rewriting the Satellite Home Viewer Act so many times well, he's going to avoid it this time, I think. 3 times he's been there to help rewrite the Home Viewer Act. As a legislative rock star for the committee, his knowledge and expertise will be missed, but I know he will become a legal movie star for the MPPA. Neil, thank you for your service to this committee and to this country. I would have hoped on his final day here we would have him actually at the witness stand so we could have him under oath. And I thank the committee for that indulgence. And now I'd recognize the vice chair of the committee, Mr. Latta, for 5 minutes.
Well, thank you, Mr. Chairman, and I will not take my 5 minutes. But I want to thank you for holding this hearing on improving the FCC process, and I appreciate our witnesses for being here today. Really appreciate that. The cost of regulation to American businesses and hence our economy is too great to ignore. Regulatory burden is the #1 issue I hear from everyone that I visit in my district. And it's amazing when you have all those different issues out there, the #1 issue from everyone, and I've done 250 visits in my district at factories and businesses since last August work period, it's regulations. Unfortunately, these job creators, many of them small businesses, are holding back from doing what they do best, and that's driving the economy and actually creating jobs, in part because of the burdensome regulations that are imposed. I have reintroduced my FCC ABCs Act from last Congress, requiring the FCC to perform cost-benefit analysis on economically significant rules, and I appreciate the Chairman including this idea in his discussion draft. Additionally, my bill would also reform the Commission's forbearance authority and biennial review of regulations by adding an evidentiary presumption in order to empower the FCC to arrive at more deregulatory decisions. With the telecommunications industry driving a significant portion of the economic growth in our country, as members of Congress, we should make sure that the FCC does not produce regulations that will hamper this sector of the economy. And again, Mr. Chairman, I thank you, and I yield back the balance of my time.
The gentleman, I think, wants to actually yield to the gentleman from Texas,
and I yield to Mr. Barton
for such time as he may consume remaining.
Thank the gentleman from Ohio. I think it's about time Neil got a real job. So we wish him well. Honestly, he's a great guy. Mr. Chairman, I have introduced FCC reform legislation in the last 3 Congresses. 2 Congresses ago as the ranking member in the minority, and last Congress with subcommittee chairman, or a subcommittee chairman Stearns. And of course, I'm happy to be on these two bills today. I seldom disagree very strongly with the ranking minority subcommittee leader, Ms. Eshoo, on too many issues, but I do disagree with her on this. I fail to see how more openness and transparency, which is primarily what these two bills do. I mean, there are other things in the bills, but it's basically an attempt to get more certainty in the rulemaking process and more openness and transparency so that the stakeholders can understand what the commissioners at the FCC is doing. I don't see that as a negative. I see it as a positive. So as you pointed out in your opening statement, Mr. Chairman, one of these bills passed the House and maybe both of them in the last Congress. So maybe this is the year or the Congress that we actually get it through the Senate and the President signs it. If you look at what's happened at NSA and you look at what's happened at the IRS and you looked at what's happened at the Justice Department, I would think those that are interactive with the FCC would want bills like these two, because I think they're much better for the American people if we modernize and make more transparent their actions. So with that, I'll yield to somebody else, or yield back to you.
I think Ms. Blackburn had
I'll
requested
yield to the gentlelady from Tennessee.
Yes, thank you so much, and I want to welcome our panel because we are appreciative that you would take your time and be with us. And Mr. Chairman, I want to thank you for so diligently pursuing FCC reforms. It is needed. I tell you, only in Washington, D.C. does it seem to be acceptable for federal agencies to be careless or reckless or unaccountable for taxpayer dollars, or to oppose reforms or efficiencies or ways that are going to allow the customers, the end users, to be better served. So I do look forward to this. We have all heard and have grown weary, actually. It seems like there's a scandal and misuse of taxpayer funds every week, whether it's the IRS or Department of Labor or Department of Justice. The list goes on and on. EPA. So putting this issue forward is appropriate, it is timely, and we appreciate that you all would be here to give us your best thoughts and recommendations. And I yield back.
Gentlelady yields back. All times expired on our side. We'll turn now to the gentleman from California, Mr. Waxman, for an opening statement.
Thank you, Mr. Chairman. I want to begin by also thanking Neil Freed for his service on this committee, and I wish him well in his new position. I hope at the MPAA he'll have occasion to visit my district more often and understand the problems of real people.
You two could travel
they
together.
have. Today, the subcommittee revisits a topic that deeply divided our committee last Congress, the so-called FCC process reform. Supporters of this legislation assert that this bill will make the Federal Communications Commission more transparent and efficient. From our perspective, it is transparent that this legislation is an effort to undermine the agency's ability to adopt new rules, protect consumers, and promote competition. And the only efficiency gained is the speed with which communications lawyers could find new ways to take the FCC to court. The bill circulated by Chairman Walden earlier this week includes the same defects as the legislation from the last Congress. It still undermines the ability of the FCC to act quickly and efficiently by putting in statute a dozen new mandatory process requirements, with each one subjecting the FCC to new court challenges. And it still alters fundamentally the agency's authority to impose conditions during its transaction review process, effectively eviscerating the public interest standard that has guided the FCC for nearly 80 years. The red tape created by this legislation is astounding. The Congressional Budget Office estimated that implementing the legislation from the last Congress would require 20 additional staff positions at the FCC and cost the agency millions of dollars every year. I don't see that there's an abundance of extra funds to devote to this purpose. And the updated draft is even worse than last year's bill. It contains new provisions that would further incapacitate the agency. Ranking Member Eshoo and I asked committee staff to consult with administrative and communications law experts to understand the impacts of the legislation. The overwhelming consensus from the independent experts we spoke with was that adoption of this legislation would be a serious mistake and that would slow the FCC to a crawl. They told us that the FCC's specific mandates in this bill would remove the Commission from the well-established precedents of the Administrative Procedure Act, which could lead to decades of litigation and breed uncertainty and confusion. The agency would be tied up in knots and unable to do much of anything except report to Congress on its adherence to deadlines. I'm pleased we're going to be able to hear from two of the experts today, Professor Richard Pierce of the GW Law School and Professor Stuart Benjamin from Duke Law School. Professor Pierce is one of the leading authorities on administrative law in the nation. He literally wrote the textbook on this topic. Professor Benjamin brings to us a unique perspective as an expert in both telecommunications law and administrative law, who has spent time working at the FCC as a distinguished scholar. I also welcome back to our committee Mr. McDowell, Mr. May, and Mr. Ramsey. Let me reiterate what I hope is obvious. Democrats are open to improving federal agency operations and efficiency, and the FCC is no exception. We proposed several reforms last Congress and will do so again this Congress. If there are sensible ways to make the agency more efficient and nimble, we should join together to do so. But we seriously disagree about the wisdom of the current effort, and I hope the majority will reconsider its plans to push this through the House. We do far too many message bills that go nowhere in the Senate. We have a real opportunity to enact meaningful bipartisan legislation that modernizes our communications and technology laws, but every day we spend arguing over this bill, which is going nowhere fast, is another missed opportunity. Thank you, Mr. Chairman.
Gentlemen, yield for just a second on the APA issue.
Yes.
Because if you look at the last section of the draft bill, we don't change anything on APA except for the Sunshine Act that you all support. That's the only, just as a matter of clarification. Nowhere else in the Act do we change the APA directly. It's only the Sunshine Act.
Well, Mr. Chairman, I'll be pleased to listen to what the witnesses who are such experts in this area have to think about what changes there are in the APA. This would be a serious matter, and it seems to sense you think it's serious as well.
Yeah, I would just direct you to line 5, page 25, section 6, effect on other laws. Nothing in the Act or the amendment made by this Act shall relieve the FCC from any obligations under Title V U.S. Code except where otherwise expressly provided, and that's the Sunshine Act.
Mr. Chairman, reclaiming my time, sure. As I understand it, it removes the Administrative Procedure Act from the FCC and creates another set of laws under which it would operate that's similar to the Administrative Procedures Act but is different. And I want to get that point clarified in this hearing. I think it's why we have hearings.
That's exactly why we have hearings, and even for bills that will go forward. Let me suggest that we have 11 minutes left in the vote, so rather than start with one person's testimony, I would recommend that we recess the committee now until after votes. So I know you're all poised and ready to go. We appreciate it, but I think it's probably best for the flow of the testimony that we recess until we return from votes immediately. Thank you. If we could everybody take their seats, we're going to restart the hearing and hear from our witnesses. I apologize for the delay, and they do expect votes again right around noon. So hopefully we can at least get through the statements of our distinguished panel members, and we'll start off with Mr. Downs, who is the Internet Industry Analyst and author. And we welcome you to the Subcommittee on Communications and Technology. And go ahead and turn that mic on, pull it up close, and we'll look forward to your testimony on this matter. Thank you, sir.
Well, thank you, Mr. Chairman and Ranking Member Eshoo and members of the subcommittee. I appreciate the opportunity to testify today on the importance of reforming processes at the FCC. My name is Larry Downs. I'm based in Silicon Valley. I'm an internet industry analyst and the author of several books on the information economy, innovation, and the impact of regulation. I've also written extensively on the impact of communication policy on the dynamic broadband ecosystem, and in particular the role played by the FCC. As the nature of technological innovation has both accelerated and mutated in the last decade in particular, the FCC's inability to eliminate needless roadblocks for consumers, entrepreneurs, and incumbents alike has reached a breaking point. The agency continues to tinker with the 21st century communications ecosystem using a 19th century toolkit. Many of the FCC's processes are badly in need of reform and structure. They lack economic rigor, transparency, expediency, and consistency. As Nobel Prize-winning economist Ronald Coase famously wrote, "If you torture the data long enough, nature will always confess." That, in a nutshell, has become the FCC's unintended modus operandi. The agency collects the data it needs to make wise and efficient decisions, but in the absence of clear guidelines and the most basic economic tools, the Commission cannot resist the urge to abandon the logical conclusions compelled by their own data in the service of vague, idiosyncratic, transient, and often unarticulated policy goals. These problems devalue much of the good work of the agency's staff and subvert the often admirable goals of the FCC's chairman and commissioners. They've created an epidemic of side effects, including reports that fail to reach obvious conclusions supported by the thorough data collection the staff performs, limiting their usefulness as policy tools to advance the FCC's long-standing charter to promote communications technologies for all Americans. Rulemakings that torture their analysis and data to justify what appear at least to be ex-ante conclusions to regulate regardless of the need or cost. Painfully slow reviews of license transfers aimed at avoiding an imminent spectrum crisis, which when approved are rendered incoherent by laundry lists of unrelated conditions, many of which become counterproductive or mooted by technological advances years before they expire. In approving the Comcast-NBC Universal merger, for example, which took the FCC nearly a year, the agency imposed 30 pages of conditions, including a requirement to run certain commercials on certain channels at certain times for a period of 5 years. And finally, past and now future spectrum auctions, poisoned by similar interventions, weighed down with so many strings attached, they either fail to achieve minimum bids or leave billions of dollars on the table. Given rapid changes in the broadband ecosystem, the FCC needs some measure of flexibility to complete its statutory mission. But applying that flexibility ungrounded by neutral principles, guidelines, and analytic processes invariably does more harm than good. Worse, the lack of structure has left the FCC with the mistaken impression that the agency can predict an increasingly unpredictable future and design what it calls prophylactic remedies for consumer harms that have yet to occur. In effect, the Commission's decision-making process is at war with the agency's own data. Congress can easily ameliorate the worst symptoms of this breakdown. The two discussion draft bills before you provide many common-sense, modest, apolitical repairs, imposing needed structure on the FCC's processes. As those of us in the technology industries have learned the hard way, the pace of change has long since outrun our ability to predict the future, even in the short term. The FCC must be cured of its addiction to micromanaging markets that are evolving even as the Commission's deliberations meander along. And it must focus its remedial and regulatory efforts on relevant consumer harms that are tangible and solvable with both precision and measurable efficacy. That minimum level of regulatory process has been mandatory for executive agencies since President Clinton ordered it in 1993, an order amplified by President Obama in 2011. President Obama also made clear he expected, though he could not require, the same basic tools be applied as a matter of course by independent regulatory agencies, including the FCC. Indeed, most independent regulatory agencies, according to a recent longitudinal survey by the Administrative Conference of the U.S., are already required by law to conduct some level of cost-benefit analysis. The FCC is one of the very few who do not have such mandates in their implementing statutes, and perhaps the only agency that doesn't do it anyway. There is also nothing novel or difficult about the added requirement the FCC consider as an alternative to specific interventions the possibility that high-tech markets will cure their own ills more quickly and efficiently and with fewer unintended side effects. That was, for example, precisely the approach taken by the Department of Justice in its separate review of the Sirius XM satellite radio merger. In a 4-page statement closing its review, the Antitrust Division sensibly found that new forms of competition driven by emerging Internet technologies would be more than adequate to discipline the combined entity, and they have been proven abundantly correct. By contrast, it took the FCC 17 months and a 100-plus page order laden with conditions to reach the same conclusion. Thank you for the invitation to appear today. I look forward to your questions.
Mr. Downs, we appreciate your testimony. We'll go now to Mr. Richard J. Pierce, Jr., Lyle T. Alverson Professor of Law, the George Washington University Law School. Mr. Pierce, thank you for being here today, and we look forward to your testimony, sir. Will you make sure that microphone's on? Thank you.
Thank you, Chairman Walden, Ranking Member Eshoo, and members of the subcommittee. It's a privilege for me to be able to appear before you today to discuss the proposed Federal Communications Commission Reform Act of 2013. I've taught administrative law for 36 years. I've written over a dozen books and 120 scholarly articles on administrative law. My books and articles have been cited in hundreds of judicial opinions, including over a dozen opinions of the United States Supreme Court. I'm also a member of the Administrative Conference of the United States. I will discuss the provisions of the proposed act that relate to the procedures the Federal Communications Commission is required to use to issue rules. I will not discuss the provisions that relate to the substantive principles FCC is required to apply in its decision-making. I am not an expert on communications law, so I lack an adequate basis to discuss proposed changes in the substance of communications law. The proposed FCC Process Reform Act would add 12 judicially enforced mandatory steps to the notice and comment rulemaking procedure required by Section 553 of the Administrative Procedure Act. Those new mandatory judicially enforced steps are a minimum 30-day period for submitting comments, a minimum 30-day period for submitting reply comments, a mandatory notice of inquiry issued within 3 years of the issuance of the notice of proposed rulemaking, mandatory inclusion of the language of the proposed rule in the notice of proposed rulemaking, and identification of the specific market failure the proposed rule addresses, a determination that the benefits of the proposed rule exceed its cost, a determination that market forces or changes in technology are unlikely to address the specific market failure addressed by the rule, advanced provision of a list of the available alternative options to all commissioners, provision of the language of the proposed rule to all commissioners well in advance of any meeting scheduled to consider a proposed rule, publication of the text of the proposed rule in advance of the meeting, adoption of performance measures for any program activity created or amended by the rule, and a finding that such performance measures will be effective to evaluate the activity created or amended by the rule. None of these procedures are in the Administrative Procedure Act. Every one of them is an add-on to the procedures in the APA. In my opinion, the proposed act would not improve the FCC decision-making process. As I explained in greater detail in my written testimony, the proposed act would have two serious adverse effects. First, it would be a significant departure from the wise decision Congress made in 1946. After 15 years of debate and an unprecedented amount of empirical research, Congress unanimously enacted the Section 553 of the Administrative Procedure Act. That statutory provision creates a uniform set of procedures that all agencies are required to use when they issue rules. The APA was one of the most thoroughly debated and carefully researched statutes ever enacted. It was premised on the belief that creation of a uniform set of procedures applicable to all agency rulemaking was critically important to the nation. The Supreme Court has spent the last 67 years resisting the periodic attempts to return to the confusing, uncertain, and ad hoc world that preceded the passage of the Administrative Procedure Act. Yet that is exactly what this bill would do. It would move us back in that direction. Second, it's a bad idea to add 12 mandatory judicially enforced procedures to a process that's already long and resource intensive. The proposed act would add many additional procedures to the FCC rulemaking process that mandatory procedures that the agency would be able to issue, amend, or rescind few, if any, rules. It would slow down the decision-making process dramatically. That is exactly the opposite of what you want to happen in a highly volatile market like telecommunications. As I discuss in detail in my written testimony, great jurists like Chief Justice Rehnquist and D.C. Circuit Judge Kavanaugh have urged rejection of similar efforts to impose such burdens on the rulemaking process. That concludes my testimony. I'd be glad to answer any questions you might have.
Appreciate your testimony, Mr. Pierce, and we'll now move to Randolph J. May, who is the president of the Free State Foundation. Mr. May, thanks for being here today. We look forward to your comments.
Thank you, Mr. Chairman. I'd like to borrow Professor Pierce's booming voice for my testimony. Chairman Walden, Ranking Member Eshoo, and members of the committee, again, thank you for inviting me to testify today. I am president of the Free State Foundation, a nonprofit research and educational foundation. FSF is a think tank that focuses its work primarily in the communications law and policy and administrative law areas. I have been involved for 35 years in communications policy in various capacities, including having served as Associate General Counsel at the FCC. I'm a past chair of the American Bar Association's section of administrative law, and I'm a public member of the Administrative Conference of the United States. So today's hearing on FCC process reform is at the core of my longstanding experience and expertise in communications law and policy and administrative law. I appreciated the opportunity to testify before this committee a bit more than 2 years ago, though H.R. 3309 and 3310 both passed the House. Unfortunately, they died in the Senate. Reform measures such as those embodied in the present discussion drafts are needed now more than ever. In my June 2011 testimony, I generally supported the proposed reforms, and I do so again today because the FCC's decision-making needs to change so that in today's generally dynamic, competitive telecommunications marketplace, the agency will be less prone to continue on its course of too often defaulting to regulatory solutions, even when there is no convincing evidence of market failure or consumer harm. The FCC still operates today with a pro-regulatory proclivity pretty much as it did in 1999 when the Clinton administration's FCC chairman William Kennard called for the reorientation of the agency's mission to account for the increasingly competitive environment evident even then. After having served at the FCC from 1978 through 1981, when President Carter's FCC chairman was initiating efforts to reduce regulation in light of the new forms of competition already emerging then, I believe that regulatory reform measures like those embodied in the discussion drafts and the few additional ones that I advocate in my testimony deserve bipartisan support. In the time that I have, without taking anything away from the significance of some of the other proposed reforms, I want to highlight the rulemaking requirements and transaction review proposals because they are especially important. It is true, of course, that as some of the bill's opponents charge, new Section 13A would require the FCC to make additional findings and undertake additional analysis beyond that presently required before it imposes new rules. For example, the FCC would be required to analyze whether there is a market failure, and it would be required to perform a cost-benefit analysis. And the Commission would be required to provide a reasoned explanation as to why market forces and technology changes will not, within a reasonable time period, resolve the agency's concerns. Frankly, in today's communications environment, you would hope the FCC would be doing these things anyway, but the reality is that it often doesn't. There's nothing inherent in sound principles of administrative law that suggests Congress should not impose particular sector-specific analytical decision-making requirements when circumstances warrant. While general theories of administrative law are nice and can be relevant in general, they are not necessarily applicable to a specific marketplace sector or regulator. And this is especially true in this particular marketplace sector, which due largely to rapid changes in technology is generally competitive. Indeed, I urge the committee to go a step further by specifying that the reasoned determination required concerning whether market forces or changes in technology are unlikely to resolve the Commission's concern must be based on clear and convincing evidence. This change will not prevent the Commission from adopting new regulations, and it is not intended to do so. It simply requires the agency to meet an evidentiary burden before adopting or revising regulations. The transaction review provisions contained in Section 13K, especially the addition that allows the Commission to condition approval of a proposed transaction only if the condition addresses a likely harm uniquely presented by the specific transaction would go a long way towards combating the FCC's abuse of the transaction review process. The agency often has abused the process by delaying approval of transactions until the applicants, quote, voluntarily agree, usually at the midnight hour, to conditions that are not narrowly tailored to remedy a harm arising from the transaction or unique to it. I also suggest the committee reform the forbearance and periodic regulatory review process by in effect requiring a higher evidentiary burden to maintain existing regulations on the books. Actually, I understand from what Representative Latta said that maybe he agrees with that. Absent clear and convincing evidence that the regulations at issue should be retained under the existing substantive statutory criteria, regulatory relief should be granted. Similarly, I propose adoption of a sunset requirement so that all rules will automatically expire after X years, absent a showing based on clear and convincing evidence that is necessary for such a rule to remain in effect to accomplish its original objective. Again, thank you for inviting me to testify today, and I will be pleased to answer your questions.
Thank you, Mr. May. We appreciate your participation in our hearing. We now turn to James Bradford Ramsey, who is General Counsel for the National Association of Regulatory Utility Commissioners. Mr. Ramsey, thank you for being here. We look forward to hearing from NARUC.
Thank you so much, Chairman Waldron and Ranking Member Eshoo, for inviting me, giving me the privilege of testifying today. I'm enthusiastic that there's, again, a focus on reform at the FCC. I guess I wanted to say, since I'm hearing the perspective, everybody's telling where they're coming from, I'm coming from the perspective of a 23-year practitioner before the agency who actually has to deal with these procedures on a daily basis, and I'm representing a group of people who are directly impacted by these procedures daily, the state public utility commissions in all 50 states, each one of your states. In my 23 years at NARUC, I've had the privilege of working with the privilege and sometimes frustration of working with 9 different FCC chairs. I started when Al Sykes was chair, and of course I'm here for Mignon Clyburn, my really good friend. And without exception, I think they've all been dedicated public servants, really trying to do what they thought was in the best interest of the country. Mignon, when she came up here, Chairman Clyburn, when she came up here before her confirmation as FCC chair, was talking to her at the NARUC offices, and she just looked up to me. We were talking about the confirmation hearing process. She said, you know, I don't really care about all this, Brad. I just want to do the right thing. And I think that's what all FCC commissioners try to do. I think the staff over at the FCC is among the most professional and hardworking of all of the federal agencies that I deal with here in Washington. But that doesn't mean that there aren't process abuses at the FCC. And the process abuses, it also doesn't mean that Congress shouldn't be looking at some ways to correct the process abuses at the FCC. There have been process abuses at the FCC every year that I've practiced before the agency, before both Democratic and Republican administrations. There have been problems that unnecessarily increase costs to taxpayers, that is your constituents, problems that increase the regulatory risk unnecessarily, for FCC policy pronouncements to be overturned on process issues that we shouldn't even be talking about. Problems that directly undermine rational decision making. I mean, if you look at some of the provisions in this bill, they're designed to make sure that the other FCC commissioners have an adequate time to look at the record and consider things that are put in the record later in the process before they make their decision. Those provisions, I think, are useful. There are also problems, I think, that the discussion draft actually will go a long way towards correcting, or at least certain provisions in the discussion draft. Is that draft perfect? There is no such thing as a perfect piece of legislation coming out of Congress. But there are some pieces, and NARUC endorses very specifically certain aspects of this legislation. It provides a good framework from NARUC's perspective for bipartisan action going forward for FCC reform. I know there are pieces that are supported, that are in there that are supported by both sides. I think it's worth pointing out here that, like the committee and Congress, NARUC is bipartisan. The people that I represent, unlike the other witnesses on this panel, are in-state experts whose interests align precisely with each representative in this room. These are commissioners that reside and work in your state, and there's not another stakeholder in the telecommunications sector that cares more about what happens to the infrastructure in your state and to the services in your state and the impact that the FCC decisions have on that than the people that I represent. And there also are few people that have the same level of appreciation of what that impact means and the expertise to provide input. I think it's significant that those same commissioners from your states have, for years, almost a decade now, supported many of the specific provisions that we endorse in this discussion. And when I look at process reform, there's so many reasons that you should be considering this carefully. One of them is that if you fix it so that the record is better, if you put in these provisions, my belief is, publishing the rule ahead of time, making sure there's an opportunity to reply to late ex parte filings and studies that have put in the record fairly close before the deadline for advocacy drops. If you give an opportunity for people to respond to these, if you give the commissioners more time to consider things that they're given, then you'll get a better decision. And you'll get a better decision because there's a better record. If you don't put in some of these requirements, and I'll mention just 3 of them, the rule to publish the text of the rule in advance, to require minimum comment cycles, which is crucial for state commissions because we have limited resources and we can't act as fast as others can, and to effectively require time for reasonable consideration of the ex partes. If with just those 3 requirements, you'll get a better record. If you don't do those 3 requirements, the people that get disadvantaged are the people that I represent and small businesses in your states and the consumer advocates in your states. We're the ones that don't have the resources and can't respond quickly. But no one benefits if we all end up in court arguing about process instead of policy. I can see my time is running down here, but I will just say, if you look at my testimony, I point out I'm litigating right now in the 10th Circuit over a decision that came from this administration. There are examples from all the administrations of process of problems. There, I think we have a reasonable chance of coming back, bringing the entire reformation of the federal universal service regime that was accomplished by the agency in 2011 back to the agency just on process issues. And if those provisions that I mentioned had been enacted into law at the beginning of 2011, I wouldn't be litigating those issues today. So I think the bill provides a useful vehicle, and I encourage you to seize the opportunity to move forward with reform. Thank you very much.
Mr. Ramsey, thank you very much for your helpful comments. We appreciate that. We'll turn now to Mr. Stuart M. Benjamin, Douglas B. Maggs Chair in Law and Associate Dean for Research at Duke Law. Mr. Benjamin, thank you for being here.
Thank you, Chairman Walden, Ranking Member Eshoo, members of the subcommittee. Thank you for the opportunity to testify today. My academic career has centered around the FCC. I teach telecommunications law. I co-author telecommunications law casebook, and I teach and write in administrative law and the First Amendment. From 2009 to 2011, I was the inaugural distinguished scholar at the FCC, and I thank co-panelist Rob McDowell for coming up with that job title for me. True story. So I should also say I have no clients, paid or unpaid, nor have I had any clients or consulting relationships since I became an academic in 1997. All right. I think I understand the concerns that motivate the FCC Process Reform Act, and I think there are quite legitimate questions about FCC processes and standards. I do have concerns about the bill as drafted, though, for several reasons. First, as has already been touched on, the bill contains many new requirements that are unique and would bring the FCC into uncharted territory. So there are neither agency nor judicial precedents that would provide guidance and clarity. And these new requirements could be the subject of litigation. That is to say, one could bring a lawsuit based on them. For instance, in addition now to being able to challenge a rule as arbitrary and capricious, which one is already able to do, a litigant can challenge the adequacy of any or all of the new findings required. My concern is this runs the risk of the bill being a jobs program for lawyers. If I were in private practice in D.C., that might be great. As a citizen, I'm not sure that it's so great. And then this uncertainty created by the new provisions is exacerbated by the fact that the provisions apply only to the FCC. And that brings me to the second concern, which is, as Dick Pierce has pointed out, the great strength of the Administrative Procedure Act is that it applies the same rules to all agencies, allowing for consistency and fairness. And this bill would undermine that consistency by creating a special set of rules for the FCC. My own view is if the bill's proposals are good ideas, I think they're worth applying across the board. If they're not worth applying across the board, I'm not sure why they should apply only to the FCC. The third concern I want to raise involves merger review. As I detail in my written testimony, the requirement of narrow tailoring. This narrow tailoring is not found in the U.S. Code. It's found only in strict judicial scrutiny. And the requirement of uniqueness of harms will, I think, make it difficult, if not impossible, for the FCC to impose any meaningful merger conditions. If Congress's goal is to eliminate the FCC's merger review, my suggestion would be it should simply repeal the FCC's merger authority. That would save everyone, companies, citizens, FCC staff, a huge amount of time, energy, and money. If, on the other hand, Congress wants the FCC to play a meaningful role in merger review, I think the legislation should use somewhat less forbidding language than this stark language of strict scrutiny. My fourth reservation arises out of provisions that would diminish the chairman's authority. This is something where I got a greater insight to when I was at the FCC. In my time there, I came to recognize the great value arising out of the clarity of lines of authority, of having a clear hierarchy, and reducing the chairman's authority would undermine that clarity, potentially creating confusion and inefficiency within the FCC. I understand the arguments for allowing, for instance, a majority of the commissioners to place an item on the agenda. One thing that particularly jumped out at me was a proposal to empower a minority of commissioners to block actions taken under dedicated authority. I think that's a different matter. The Commission makes thousands of decisions every year, and businesses and individuals rely on the predictability and speed of the FCC's decision-making process in resolving those matters. So changing that process may unsettle a lot of reasonable expectation. Fifth and finally, the bill creates additional procedures that I fear will confer little, if any, benefit. Notices of inquiry, which of course don't appear anywhere in the APA and only one provision of the United States Code, sometimes make sense, and the Commission sometimes uses them. But requiring notices of inquiry will further ossify the rulemaking process. And I think the same is true of a requirement that proposed rules be issued with a notice of proposed rulemaking. The Commission already sometimes or often puts out proposed rules with its notices of proposed rulemaking. But requiring them, I think, adds cost and very uncertain benefit. And it will push rulemaking even more into a rule-adopting process in which all the important decisions are made before the APA process even starts. That is to say, the danger is that the APA process becomes kabuki theater and public comments arrive after all the meaningful decisions have been made. So the concern is, in general, these provisions will not make the FCC regulation better, just more laborious. I see that my time is up, so I will stop there.
All right, we'll get to you on questions, I'm sure, and have a chance to elaborate. Thank you for your testimony and your participation in the hearing, Mr. Benjamin. We'll now go to the Honorable, I guess we still call you that even though you're out of office now, Robert M. McDowell, former Federal Communications Commission member and visiting fellow at the Hudson Institute. And Mr. McDowell, we really appreciate your coming in today to give us your unique perspective as a former commissioner and now outside of the portals can speak freely as you did when you were inside the portals. So we welcome your testimony, sir.
Thank you, Mr. Chairman, and Ranking Member Eshoo, and all the members of the subcommittee. It's terrific to be back before you, my first time back since leaving the Commission just about 7 weeks ago. And I did want to also make a special note to thank Neil Freed for his many, many years of public service. I've had the privilege and the honor of working very closely with Neil on, I can't even count the number of issues over the years, and he's been a terrific colleague and a friend, and we wish you well in the movie business. So we'll see you at the movie theater, I guess. So currently I do serve as a visiting fellow at the Hudson Institute's Center for Economics of the Internet. Having said that, all of the views I express today are purely my own, and they may be very lonely ideas if no one else agrees with them, but I'll say them nonetheless. FCC process reform is not necessarily the most glamorous of topics, but it is an important one, and I commend the subcommittee for its ongoing work in this area. The FCC, after all, regulates about 1/6 of the American economy and really indirectly affects the rest. Just as important, the Commission also serves as a regulatory template for countries across the globe. The ways in which the FCC considers proposed regulations and goes about shaping their substance has a direct effect on the U.S. economy and ultimately not just American consumers, but consumers around the globe. In short, to paraphrase Chairman Emeritus Dingell, those who control the process also control the outcome. Accordingly, it is prudent for Congress to cast a bipartisan oversight eye on the processes of all administrative agencies. Chairman Walden and other members should be commended for sparking this conversation with the legislation from the last Congress, as well as this year's discussion drafts. But before going further, I would be remiss if I did not mention the need for a fundamental rewrite of our nation's laws regulating the information communications and technology sector. Such a comprehensive rewrite has not occurred since 1996, and even that left in place legacy stovepipes that regulate technologies rather than just market conditions. Today, consumers don't know or usually don't really care if their data is transmitted over coaxial cable, fiber optics, copper, or wireless platforms. In fact, usually data is being transmitted over hybrid networks that we're not even aware of. It's seamless to the consumer. Instead of directly focusing on whether the marketplace is experiencing a concentration of market power, abuse of that power, and resulting consumer harm, today's regulations draw their authority from the nearly 80-year-old Communications Act of 1934. FCC will celebrate its 80th birthday next spring. And that act is based on 19th century style monopoly regulation, which rests on an even older foundation. Therefore, having different regulations based on the type of technology used and their history rather than on current market conditions is likely distorting investment decisions. For the sake of improving America's global competitiveness, I respectfully urge Congress to move ahead as soon as possible with a comprehensive rewrite of our communications laws with the aim of promoting investment and innovation while protecting consumers. Putting some of this into tangible terms, in 1961, when consumers had a choice of one phone company and 3 broadcast networks, the broadcast TV networks, the FCC's portion of the Code of Federal Regulations filled just 463 pages. In 2010, the FCC's rules filled 3,695 pages, despite the bipartisan deregulatory mandates of Congress as codified in the Telecommunications Act of 1996. Today, the Commission's rules fill 3,868 pages, despite President Obama's call in 2011 to pare back unnecessary rules. In short, in a marketplace that is undeniably more competitive than it was in 1961, the FCC's regulations grew by more than 800%, as just measured in the number of pages, with a nearly 5% increase just since 2010. In contrast, the American economy has grown by a much smaller number since 1961, by about maybe 370%. Some of these rules are necessary, but are all of them? Shouldn't the Commission have the authority to weed out all outdated rules the way it can and must for rules affecting telecommunications services under Title II, as mandated by Sections 10 and 11? Forbearance authority should apply to all platforms and industries, not just traditional telecom services. Along those lines, as my fellow witness Randy May has advocated for quite some time, requiring the Commission to justify new rules with bona fide cost-benefit and market analyses would help better inform policymakers and restrain them from issuing unnecessary rules. Exercising discretion and regulatory humility while being patient with markets can create a better experience for consumers. Similarly, new rules should sunset after a definitive period and the renewal should be justified from scratch in new proceedings with public notice and comment. The continuation of old rules may be absolutely necessary, but let's test that premise every few years. I see I'm running out of time. In fact, I'm way out of time. But other ideas to explore should include, just for respectful mention here, limitations on unnecessary merger conditions that have nothing to do with the attendant transaction, shot clocks with exceptions, consolidation of industry reports, and regulatory fee reform, among many others. Lastly, I'd like to end with a bipartisan applause line. Let's have Sunshine Act reform so more than 2 commissioners can meet to discuss substance without having to call for a public meeting. Well, there's no applause. But anyway, hopefully, let the record, thank you. Let the record reflect there was thunderous applause from both sides of the aisle after that. Thank you for the opportunity to speak before you today, and I look forward to answering your questions.
Mr. McDowell, as always, thank you for your testimony, as entertaining as it always concludes. We appreciate all of the witnesses. I'll start off with some comments and questions. First of all, picking up on your last comment, I know the desire of the agency to be able to have commissioners more than one meet together without a public setting. The irony coming from the state of Oregon that pioneered public meetings requirements both for its legislative assembly and its agencies is that that's the one piece of this bill that would actually allow activities to occur in private that are otherwise public today. And it's also the only provision, correct me if I'm wrong, that actually amends the APA itself. So the irony is my friends who object to these other reforms and requirements, alleging that somehow this committee would only be affecting the APA for one agency, want to affect the APA for one agency to allow members of the commission to meet in private without a public setting and do their business. Is that not correct, Mr. McDowell? With all due respect to the applause lines.
Yes, Mr. Chairman, I agree with that.
Thank you. Now, having put that on the record, let me go to the expenditure piece. And I would put in the record of unanimous consent the Congressional Budget Office cost estimate from March 19th of 2012, which looked at the predecessor bill and I think was referenced by the distinguished gentleman from California. The CBO also went on to say that given assuming appropriations and necessary amounts for personnel and information technology, under current law, the FCC is authorized to collect fees sufficient to offset the cost of its regulatory activities each year. Therefore, CBO estimates that the net cost to implement the provisions of H.R. 3309 would not be significant, assuming annual appropriation actions consistent with the agency's authorities. Yes, it does require a few more people. Guess what? Open processes do. Mr. Ramsey, I'd like to go to you as representing the public utility commissions around the country. As you know, my senior policy advisor, Ray Baum, behind me, chaired the Oregon Public Utility Commission. Much of what we're proposing here is actually already accomplished by many public utility commissions in their processes, is it not? Don't they require rules to be published in advance? Don't they almost prohibit ex parte contact? Don't they require a much more transparent process, which is what we're getting at here?
Yes, sir. Generally speaking, my experience has been that the state regulatory process is more transparent and less subject to what process lapses than the FCC and other federal agencies.
And do you think it's right that a federal agency can require as a condition of a merger, quote-unquote, voluntary actions that they could not require under their statutory authority otherwise?
Well, NARIC hasn't taken a position on the merger condition authority in the statute, so I...
All right, I'll go to Mr. McDowell. Do you think it's right that a federal agency can require 2 parties, or 3 or 5, or however many in a merger, to do certain things that it could not require them to do under their statutory authority? And in fact, there are people maybe headed to the FCC who believe that authority should be used that way to affect the marketplace. And wouldn't that have an effect on other players in the market not subject to the merger? And would that be fair to them?
That was a compound question, so I want to make sure I hit all parts of it. So, yes, I agree that that is problematic. I've been a long time critic of imposing merger conditions that are not related to the actual transaction. It does start to enable the Commission to impose effectively a rulemaking or other policies not envisioned by Congress, when in essence the FCC is legislating through that type of process.
And Mr. Benjamin, I want to pick up on one point on the notice of inquiry requirement that you objected to. We should also, for the record, point out that's only a requirement if in the prior 3 years the Commission has not done work in that area. So it's not required every single time. It's just to try and get some background information ahead of time if they're going to act where they haven't acted before. Is that not accurate?
Right. So I think the way it's written, you have to have either a notice of proposed rulemaking, which would have rules in it, or a notice of inquiry, or a judicial order. So one way or another, before you start the new NPRM, you will actually have already had a huge amount of process beforehand through a notice of inquiry or through a prior set of rules in an NPRM.
Yeah. So our goal here is, and we're open to, many of you have had very good recommendations about things you think could be done better, differently. But our goal here, and we'll take those into account as we go into a markup at some point and try and get this right. We don't want to hogtie the FCC. We don't want to add to litigation. Believe me, I get a round of applause in any town hall I do when I confess I'm not an attorney. And so I have no interest in adding to the legal establishment's billing hours. I'm actually trying to improve public process and open this up and do what other agencies already do and do what the President has suggested agencies not constituted as the FCC is do. And we'll continue to work on this till we get it right. But we will move forward. So with that, my time has expired. And we have, oh yes, I have one other UC I need to do, which is a statements of support from various entities. A quote from the United States Chamber of Commerce, National Association of Regulatory Utility Commissioners, National Association of Broadcasters, U.S. Telecom, Americans for Tax Reform, Citizens Against Government Waste, National Cable and Telecommunications Association, Comcast, NTCA, and AT&T. Statements in support of the legislation, unanimous consent to enter into the record. With that, my time has expired.
Were they voluntary, Mr. Chairman?
You know, I'll let you read them for yourselves, and yes, I think they are all voluntary.
Is it my turn now?
It's your turn.
Okay.
And just, and I'll turn to my friend from California, whom we have a little disagreement on parts of this bill with, but I would tell you we have 12 minutes left in the vote, so when she concludes, then we'll recess again and then come back.
Okay,
I now
I'll go as
recognize my
quickly
friend
as
from
possible.
California.
Thank you, Mr. Chairman. And to all of the witnesses, I just want to share the following with you. In listening very carefully to each one of you, I leaned over and I said to Mr. Waxman, isn't it so extraordinary that we have the level of expertise that's represented at this table in our country? It makes me feel very, very proud. Whether I agree with some of your views or not is not the point, but it's really nothing short of remarkable, so thank you. I love hearings, and I always learn a lot, so thank you for being here and offering what you did in your testimony. I just want to get something like straight off the table so it can be just yes or no. Do you all support a standalone action on the FCC Collaboration Act as a way of allowing FCC commissioners to collaborate outside of official public meetings, yes or no? To start with Mr. Downs.
I don't have an opinion on that.
Okay.
I think it's a good idea, but I'd like to see it as an amendment to the Government and the Sunshine Act. It applies to all of the agencies that are run by collegial bodies. There's no reason, again, I see nothing unique about the FCC here. It's the same as the FERC or any other agency run by a collegial body. This would be a big improvement.
I think what I appreciate that. I think what needs to be stated for the record, and I think the chairman may have thought that it was the reverse of what goes on in what takes place in his home state. There would still be there's a requirement in this legislation that's bipartisan and bicameral for transparency. So it's not that commissioners can go off in secret, the public never knows what they have talked about and discussed, and that it just remains there in that in a secret bubble. That's not the way the legislation is drafted. So, Mr. May, yes or no?
I can't answer yes or no, but I'll be quick.
Mr. Ramsey?
Yes.
Mr. Benjamin?
I agree entirely with what Dick Pierce said.
Okay. And
I don't have an opinion if it's separate or together, but it's a good idea nonetheless.
good. My sense of what really underlies more of this effort surrounds one issue, and that's the whole issue of the FCC's authority to review acquisitions and mergers. And I think that that's where there is concern. I think that's where there is disagreement. I think that's where there's agitation. I think that there's aggravation. And I think that's driving this more than anything else, because there are some smaller reforms that can be made that we can do on a bipartisan and I think bicameral basis. But I do think that that this is the area that really causes the most heartburn, both pro and con. Now, Mr. Pierce and Mr. Benjamin, I think that you made references to this in your written testimony, and I want to give you the opportunity to elaborate on it. I think that the draft legislation only allows the FCC to impose conditions that are, quote, narrowly tailored to remedy a harm that arises as a direct result of the specific transaction. But these transactions are huge in terms of their impact on the American people, on consumers, on media consolidation, which I think it really goes to the heart of democracy. So would either one of you care to comment on what I just said?
Sure. What's remarkable to me about the language is that it is the language of strict judicial scrutiny and narrow tailoring. When it's if I were a judge, I would think Congress chose this language for a reason. They chose it because they were picking up on strict judicial scrutiny, because it's a term of art.
Well, it has been chosen for a reason. The language
is
is
there.
there.
Only from that.
It didn't self-create itself.
I understand. And just to be clear, when courts apply strict scrutiny, narrow tailoring, they require that the government use the least restrictive means in order to achieve a goal. And that's a very difficult standard to meet. As Justice Breyer noted in dissent in a couple of cases, any clever or creative lawyer or judge can come up with some other less restrictive means. So I think as crafted, I think it will make it difficult for the FCC to have any meaningful merger conditions. And separate question is whether the FCC should be in the business of reviewing mergers at all. My only recommendation would be then just do it and avoid a lot of confusion.
Well, I think that there are some here that believe that they just shouldn't. You know, I don't know how many, but I think there are some that that hold that view, and they're entitled to it. But I think it's very clear that there's a public interest standard that the FCC is charged with, and this has a lot to do with the interest of the public in the country. This isn't just about getting into some menacing details just to be complex and complicated. Would you like to comment, Mr. Pierce?
I didn't address this in my prepared testimony because it struck me as an issue of substantive communications law, and I'm not an expert in that. I will change hats, though, and tell you I am an expert in antitrust law. That's another subject I've been teaching for the last 30-some years. Mm-hmm. And I agree completely with Mr. Benjamin that it would make a lot of sense to take the FCC completely out of this. The FCC doesn't know much about antitrust law. The FTC and the Department of Justice know a lot about antitrust law. They have the power to impose conditions. They regularly impose conditions on mergers. Those conditions are specifically tailored to address the competitive issues that are raised by a proposed merger. That's something the FTC and the Department of Justice Antitrust Division know a lot about, and the FCC knows very little about. So I agree completely with Professor Benjamin that the far more sensible thing would be a statutory change that would probably require about 10 words that says the FCC has no power over mergers. That's exclusively the realm of the DOJ and the FTC.
Mr. McDowell, will go to you, but I have to excuse our colleagues. We're down to 5
expired
minutes.
anyway.
So go ahead.
2 seconds. I think actually there's an emerging headline right here, which is I would agree.
You would agree?
I would agree. I mean,
with what?
The antitrust review is a form of public interest review. So DOJ or FTC, under their antitrust review, they're looking at harms to consumers. And that the public interest standard of the FCC is really ill-defined, and that's why you get these merger conditions, which sometimes have nothing to do with the emerging transaction and any resulting consumer harm. So we might be onto something here, bipartisan.
I agree as well, Mr. Chairman.
All right. I've got to cut this off right now because we've got less than 4 minutes for the vote on the floor. They expect a few votes thereafter, like 15 minutes. So I'm going to suggest we'll try and come back here about 1 o'clock, a little after 1, if that works. If there are others who have questions.
1 o'clock. I have an appointment at 1:30. Otherwise, I'm here, and I wanted to get my chance.
Yeah. Okay, we'll come back.
1 o'clock?
Yeah, I'm just speculating that because they said votes about 12:30, 12:45. By the time we get back, it'll probably be a little after 1. If we're back sooner, we'll start sooner. But to give them, you all plan 12:45. How's that? And if we can get back here, at 12:45, we will. Because I want to make sure other members have their chances to ask questions of our distinguished panel. With that, we'll stand in recess.
Yeah.
but they give
We'll call back to order the Subcommittee on Communications and Technology on our Improving FCC Process hearing, and we appreciate your indulgence. I hope you all had a chance to get out and get a little lunch or something while we were voting, and you didn't. Uh-oh. Well, sequester strikes again. We're going to go now to the Vice Chair of the Subcommittee, Mr. Latta, for 5 minutes for questions.
Well, thank you very much, Mr. Chairman. Appreciate that. And again, thanks for our witnesses. We've had just a few votes this morning, and appreciate your willingness to stick around. Mr. May, if I could ask a question in regards to forbearance reform at the FCC and get your thoughts on that.
Thank you, Mr. Latta. In my view, it was pretty clear when Congress put the forbearance authority in the 1996 Act that it intended it to be used when appropriate as a deregulatory measure when competition warranted. And I think the fact of the matter is that and that's also true of the regulatory review provision that follows it. I mean, the periodic regulatory review. The fact of the matter is that the forbearance authority has just been little used as a deregulatory tool. So what I've recommended, and I think you've just introduced a bill which may be somewhat along these lines, is that without changing the substantive criteria in the forbearance provision, that is protecting consumers and protecting the public interest, that none of that would be changed, but that the Commission, in order to maintain regulations when as a petition to forbear, that it bear the evidentiary burden. In other words, there be a presumption that the statutory requirements aren't met absent clear and convincing evidence or some type of burden. And I think by doing that, without changing again the substance of the criteria, just as a matter of process and procedure, it would lead the tool to be used more as I believe Congress intended when it included it in the Act back in 1996.
Thank you. Mr. McDowell, could I get your thoughts on forbearance reform?
Yeah, as I've said in my written and oral testimony, Congressman, I think it would be a terrific idea to expand that to more than just telecommunication services, which is what Congress did in the 1996 Act. Now, having said that, there's a little footnote, which is Section 336, for some reason referred to as Section 202H. I don't know why. Who actually comes up with
Is your mic on, Rob?
Yeah, it is. The little light
Yeah.
is on,
Yeah,
but
right.
I'm not speaking to it. Sorry. Want me to start over?
No.
Okay.
Nope.
So there is so our annual or quadrennial media ownership review is also supposed to be a review and to deregulate as more competition comes into the media space. But beyond that, for cable, for wireless, and other areas, the Commission does not have forbearance authority. So I think it would be constructive to expand that authority to all aspects of what the Commission regulates.
Thank you. Mr. Ramsey, if I could turn to your testimony, and it's kind of interesting because you state something here that I had mentioned in my opening remarks, that you state that unfortunately, especially when there's certain lapses that occur, unfortunately when that occurs, those with limited resources, small businesses, state commissions, consumers, consumer advocates are just disproportionately disadvantaged. And that's what I hear a lot back home from all these smaller companies out there that, they don't have the resources. And could you go touch on, just elaborate a little bit on that, how you see that for those that would be disadvantaged that have more limited resources?
Well, the problem is if you have fewer resources and you get, and again, I can go back to the transformational order that revised the entire universal service program at the federal level. There were literally hundreds of items that went into the record shortly before the deadline for further advocacy dropped. And if you only have one or two lawyers, and in my case it's one lawyer, there's no way that you can go through and look at all of those materials and respond really at all, whereas larger, better funded people frequently can. In fact, larger, better funded people are frequently the source of a lot of the last minute filings. So in this particular case, there are 2 or 3 provisions that I cite in my testimony that would level the playing field a little more for the consumer advocates, the state public utility commissions, and the small businesses and small entities.
Because that would also really impact those startups out there. that are
Yes, I
trying
would
to
think
get
so
going.
too. The people with limited resources.
And I've met with a lot of the smaller startups, and they're always very concerned because they're just getting started, and all of a sudden they don't have those dollars that they have to try to meet these regulations that are in place. And Mr. Chairman, I will yield back the balance of my time. Thank you very much.
Gentleman yields back the balance of his time. Chair recognizes the gentleman from California, Mr. Waxman, for 5 minutes.
Thank you very much, Mr. Chairman. I want to, before I get to my questions, make a brief comment about the subject that was raised before we broke, and that was whether the FCC jurisdiction on the public interest is something in addition to the role of the Department of Justice and the Federal Trade Commission. Under the test, the FCC will approve a transaction if, considering the potential consumer benefits and harms, it determines that the transaction is in the public interest. That's a little different than just the antitrust issues. For example, the FCC looks at the diversity of voices. They'll see whether certain populations are being served, low-income people, disabled people. They'll look to see what the impact is on jobs. They'll look at questions of access to telecommunication services. All of these are part of what the FCC deals with when we talk about public interest. The DOJ process is entirely confidential. The FCC process is generally open with public comment and advocacy, subject to certain exceptions for proprietary information. So I don't want to leave anyone with the impression that we all agree, and maybe you really don't all agree when you think about it, that the role is duplicative or less than critical for the FCC to maintain that power. When Chairman Walden circulated the discussion draft earlier this week that adds new provisions to the bill that was passed by the House last year, I believe these provisions further incapacitate the FCC, and I'd like to ask our witnesses questions about two of these provisions. The draft legislation contains a new provision that requires the Commission, when considering a rule with an economically significant impact, those are the words, to, among other things, quote, make a reasoned determination that market forces and changes in technology are unlikely to resolve within a reasonable period of time, end quote, the problem the Commission intends to address in the rule. In other words, the new language requires the FCC to determine whether technology and market changes will solve a problem and negate the need for regulation before issuing a rule. Mr. Ramsey, in your testimony, you suggest that this provision seems at best unnecessary because regulators should take a technology-neutral or functional approach to oversight of any market sector. Do you think basic principles like protecting consumers and promoting competition should be linked to changes in technology, and are regulators in a good position to make predictive judgments about future changes in technology?
I think the part of my testimony that addresses that was focused on the fact that technology and technology changes are only relevant to the extent that they actually impact market forces. The reasons for regulation, NARIC's been on record for years, the reasons for regulation don't change, ever. And they don't change based on the technology that's being used to provide a particular service. So in the case of where the regulation, I'm sorry.
Excuse me. Do you think this language is important to have, or do you think the?
I think the reference to technology is not necessary. It's perhaps a little confusing in the context of that Section 3, and it doesn't add anything to any type of determination of the level of competition that exists.
I thank you for that answer. I want to move on to some other issues. The Procedure Act, what is it called? The APA applies to all agencies, and this bill would accept that, which the chairman pointed out to me, that his bill specifically says that they're not excluding, nothing in this act or the amendment made by this act shall relieve the FCC from any obligations under Title V United States Code except where otherwise expressly provided. Now, Mr. Pierce, you've indicated that this adds another layer of requirements on the FCC which could be litigated, and what was once litigated under the APA may not apply when there are new provisions. Is that a correct statement of your view?
That's correct, and actually the provision you were just referring to is a good illustration of that. I mean, certainly nothing wrong with. In fact, would be laudable for the FCC to look at the relationship between market forces and technology and the need for regulation and look at the likelihood. But as soon as you put that in the statute, you've got more lawyers' work. And when it's in an agency-specific statute, the likelihood is it'll take 15, 20 years before we get a settled judicial interpretation of what that means. And I don't have any idea what that'll, and I don't know what the triggering language will be.
I thank you for that answer. I want to, in the few little time I have, this draft legislation also contains a new provision that would require advance notice to the commissioners of any decision or action taken at the bureau level, known as delegated authority. And the provision empowers 2 or more commissioners to block any use of such delegated authority, instead require that the issue be considered by the full commission. So 2 members can, in effect, hold hostage things that are routinely done at the bureau level. Now, most of what FCC does in 2012, there are 165 items released by the full commission. In 2014, items released at the bureau level. That means 92% of all the actions the FCC took last year were done pursuant to delegated authority at the bureau level. So my concern is that if 2 commissioners could block the exercise of this authority and require what could have been a routine matter to be addressed by all 5 commissioners, that's going to be an extra burden. It's sort of like the Senate. They can stop things from happening by putting holds on nominees or requiring a threat of a filibuster. Professor Benjamin, would you be concerned this might allow a minority of commissioners to frustrate the will of a majority or the chairman's agenda, potentially adding weeks or months of delay to routine actions supported by the majority?
Yes, the serious question would be, why would you want to empower a minority that way? Because there really are thousands of decisions that we're talking about, and right now there are fairly clear lines of authority in the commission, which makes for greater efficiency. So if I were a business before the agency with a routine matter, I'd be concerned.
Thank you. My time's up, but Mr. McDowell wanted to respond.
We'll do that on Mr. Scalise's time, I think. Mr. Scalise?
If the chairman so inclines, could I yield to the chairman?
I would appreciate that. Thank you. So I want to point out why we've added that provision. And Mr. McDowell, as a commissioner, you can please feel free not only to weigh in on Mr. Scalise's time subsequently yielded, but also on what I'm about to say. So it is routine, Mr. Benjamin, that they have this delegated authority and these things go through. But there's also been a custom, I believe, of 48-hour notice for the other commissioners, so they know what's going through on delegated authority. Recently, there was a case where an item was put up on delegated authority on a Friday night, triggering the 48-hour notice over the weekend. Now, I don't think there was any mischief in that, but at some point here, you could have a lot of mischief occur over a weekend and the others is just done. And so we're saying, 2 commissioners could say, wait a minute, whoa, what are you doing on supposed delegated authority? Because I don't think that's always clearly spelled out. But Mr. McDowell, are we hitting on something here?
A little bit of history here. Is this mic working? Or should I be bellowing? Okay. So a little bit of history here. First of all, it's rare for commissioners to ask for anything that's being done on delegated authority to be elevated to an 8th floor vote. It wouldn't be, with all due respect, akin to a hold in the Senate. What it is asking for an 8th floor vote on these things rather than the Bureau issuing the rule. And, before this hearing, I polled some of my former staff to ask them how many times did we actually ever want something to be elevated to an 8th floor vote. And we could, count on less than one hand the number of times in my 7 years there where that would actually happen. So it wouldn't hold things up per se. What it actually might do is, in a way, speed things up, because Bureau decisions can be brought to the 8th floor through petitions for reconsideration and other administrative vehicles, and that takes time to get to the 8th floor. So you could actually be short-circuiting that sort of appeals process. And also keep in mind it's very rare. And by the way, in the past when it happened, one of the instances had to do with a switch digital issue and set-top boxes during Chairman Martin's tenure, and the other 4 commissioners, 2 Republicans and 2 Democrats, we were very concerned about the direction that was heading in. It was an enforcement proceeding. So it was a bipartisan issue. Same with some other issues that I worked with. Also,
make it real quick because I'm using up his time. So let's go to Mr. Scalise. Thanks for your indulgence.
Thank you for yielding back. Those are the exact questions I was thinking of asking myself, Mr. Chairman. Appreciate you asking them in a much more eloquent way with that great radio voice that you have. I'm glad that we're having the hearing on FCC process reform. I was a little surprised at the beginning of the hearing that there were some that were expressing objection or concern about us taking up FCC process reform. And obviously, Mr. Chairman, you've got two bills on this agenda that we're talking about, and both of them deal with, I think, very important reforms. But when you look at it, the IRS serves as a poster child for what happens when a federal agency thinks that they're no longer accountable to the American taxpayer. And you just look at the abuses that are happening because they weren't reformed, because they didn't think that they had to answer to anybody. And so when we talk about reforming processes at the FCC, it's critical that Congress play this role. And look, if the Senate doesn't think it's important to have transparency and accountability and reform, let them go out and defend it. But shame on us if we don't exercise our responsibility in making sure that these federal agencies that we oversee are accountable, because we've seen some troubling examples at the FCC. And I think, Mr. Chairman, you pointed out some real concerns, especially as we've seen with mergers in the past, and then the comments by Mr. Wheeler, where he, in essence, was tacitly condoning the practice of the FCC literally just trying to hold up a merger unless companies would accept regulations, de facto regulations that Congress didn't even pass. So Congress said, we don't think that this should be a law, and somebody at the FCC who thinks they're unaccountable says, I think it should be a regulation anyway, and even though I can't get it approved, I'll just hold up a company's merger unless they agree to something that Congress doesn't even think should be passed. And I think that's a major concern of a lot of us. I think there's some real issues that need to be pursued on that. We need to get involved congressionally and stop them from doing this. And Commissioner McDowell, my last, I guess, few seconds here, I want to ask you about it. First, I want to ask, does anybody on the panel think it's okay for the FCC to shake down a company, to hold up a merger over requiring them to accept the regulation that Congress didn't even pass? Does anybody want to defend that practice? I'm glad to see it's sort of like the thunderous applause you had, Commissioner McDowell. Nobody wants to defend it, but did you see it when you were at the FCC? Did you see that kind of what I think is unethical activity?
Sure. I mean, there are reasonable differences of interpretation of what the public interest is. I've had a lot of conversations with my colleagues over the years over this, and some think that anything that it benefits the public is the cost of the transaction. I disagree with that. I think it has to do with, is there a merger-specific harm to consumers that needs to be cured? Others think that it's a broader interpretation of the public interest standard, but that's precisely what the bill, I think, tries to address, is to put a fence around that, a definition around what the public interest standard would be.
I think that would be important to have. So I thank you, and I thank you, Mr. Chairman. I yield back.
Now recognize the Chairman Emeritus of the committee, the gentleman from Michigan, Mr. Dingell.
Mr. Chairman, I thank you for your courtesy. I commend you for this hearings. Like the Chairman, I am very much concerned about the somewhat curious functioning of the Federal Communications Commission. So I performed a very thoughtful analysis of the Commission Reform Act to see how it works. And one of my first concerns is it seems to affect, in a curious way, 67 years of administrative law and related jurisprudence. It subjects only one federal agency to unique administrative procedures that will be different than all of the others and will open the door to years of litigation and uncertainty, ultimately stymieing, I think, rather than streamlining the work of the Commission. My questions this morning are directed to Mr. Benjamin, and they concern only the draft Federal Communications Process Reform Act. I hope you will oblige me, sir, with yes or no answers. Mr. Benjamin, with respect to the Commission's rulemaking authority, I note that Section 13A2 of the draft bill mandates the Commission to fulfill a number of new requirements prior to amending or adopting a new rule. Is it your understanding that a party could challenge the Commission's completion of such new requirements in court? Yes or no?
Yes.
Now, Mr. Benjamin, and the practical effect of such judicial review would be to slow, or to hinder the Commission's ability to promulgate new rules? Yes or no?
Yes.
And it would be a significant change in the Administrative Procedure Act, would it not?
Yes, with respect to the FCC. Yes.
Now, Mr. Benjamin, the new requirements in Section 13A2 contain undefined terms, such as, quote, specific market failure, quote, actual consumer harm, quote, burden of existing regulation, and, quote, reasonable period of time. Is it probable that interested stakeholders will challenge the Commission's application of such terms in the event stakeholders disagree with the Commission's ruling on a particular matter? In court, yes or no?
Yes.
Now, Mr. Benjamin, again, the practical effect of such challenges would be to hinder and to slow the Commission's ability to agree on new rules or to amend or rescind existing rules. Yes or no?
Yes.
Now, so far it would seem then that one of the draft bill's primary effects would be to sand the gears of the Commission when it comes to rulemaking. I'd like to turn my attention to the draft bill's effect on the Commission's merger review authority. Now, Mr. Benjamin, Section 13K1A requires that the Commission impose conditions on transactions and transfers that are, quote, narrowly tailored to remedy a harm that would likely arise as a direct result, close quote, of such transactions and transfers. Is it your opinion that this requirement will invite strict scrutiny by the courts of merger conditions imposed by the Commission? Yes or no?
Yes.
And be a fine opportunity for repeal and judicial review, right?
Sorry, repeal.
That these conditions and so forth
Oh, yes.
Be a fine opportunity for judicial review. Now, Mr. Benjamin, is it your opinion that it will be extremely difficult to craft merger conditions that would satisfy Section 13K1C of the draft bill, which specifies that such conditions address a harm, quote, uniquely presented by the specific transfer of lines, transfer of licenses, or other transactions, such that the harm is not presented by persons not involved in the transfer or other transaction? Yes or no?
I think I'm seeing a question, yes.
And that's a wonderfully complex sentence, too, isn't it? Now, Mr. Benjamin, additionally, I note that Section 13K2 of the bill prohibits the Commission from adopting voluntary merger conditions that are not consistent with the conditions I have mentioned in my previous questions. Is it your opinion that such prohibition would serve as additional roadblock to merger approvals and to potentially diminish, if not eliminate, the Commission's role in merger reviews? Yes or no?
Yes, in combination with the other provisions, I think it would.
I'm running out of time, and I apologize to you. Now, finally, is it correct that the draft bill provides no additional authorizations of appropriations or personnel for the commissions to comply with the new requirements of the legislation, which would impose a demand for new personnel, money, and so forth to the agency? Yes or no?
Yes.
So the long and short of this is that the draft bill then could conceivably hinder the Commission rulemakings, but also severely restrict its ability to approve mergers. At this point, I'm rather distressed to note that the bill would impose a kind of curious Magnuson-Moss rulemaking requirement on the Commission, which will not streamline its processes or provide it with resources with which to comply with the draft bill's new and more onerous mandates. I say this to you, Mr. Chairman, with affection and respect, and the hope that the committee will continue to seek the views of stockholders and stakeholders about the draft bill that will enable it to work to expeditiously conduct the business of the Commission. And I would hope that the thoughtful work of the committee will enable us to solve some of the questions that appear here to stand in the way of writing good legislation. I thank you for your courtesy to me.
Thank you. The gentleman's time has expired, and at this time the chair recognizes the gentleman from Illinois for 5 minutes.
Thank you, Mr. Chair, and thank you, gentlemen. And you made it to the bottom row, so you're almost about to go home. Congrats. Thank you for being out here. The discussion we're having is important regarding the efficacy and efficiency of the regulatory environment. In looking through the written testimony, one statement that really caught my eye in Mr. Downs' testimony was transfers delayed are consumers underserved. That sums up a lot of this debate quite nicely. We're all trying our best to complete work that will best serve our constituents, but the problem is that overly caustic and non-standardized regulations keep delaying the possible benefits of the changes in the telecommunications industry for our constituents. With the continued advances of technology occurring at such a rapid pace, I do believe that current FCC process needs to be reformed to deal with such a unique industry. That brings us to the topic of today's hearing, the draft legislation for FCC process reform and the FCC Consolidated Reporting Act. We discussed similar legislation in the 112th Congress, which actually passed the House in a bipartisan manner. And I'm happy to see that we're back today discussing what I believe are much improved versions of those pieces of legislation. The FCC process reform draft will make great strides in improving the predictability, efficiency, and most importantly, the transparency of the FCC and its operations. Government transparency is a major key to gaining the trust of the American public, and this draft legislation includes a number of provisions that will not only standardize many of the actions at the FCC, but will also make them more transparent to the general public. I'd also like to add that I do appreciate the efforts of former Chairman Janikowski, Acting Chairwoman Clyburn on many of these issues. As I've said before, though, statutory authority should be what drives decision-making process at the FCC, not the discretion of whomever may be the chair during a specific period of time. In response to some of the questions, however, that we just heard, I'd like to ask Commissioner McDowell. I'm going to give you a number of questions, and we'll do the yes-no thing if that works for you. While most agencies are subject to the APA, they don't all rely on procedures that differ to varying degrees, such that no agency actually has the same process. Is that correct?
Exactly, yes.
Do the new requirements in the bill requiring the FCC to actually justify its actions prior to adopting a rule constitute good government practices that will result in better rules?
Yes.
Do stakeholders currently challenge most of the Commission's significant decisions in court, even when the FCC is on relatively firm ground?
Pretty much everything the FCC does gets appealed, yes.
Understood. Has poor FCC process and weak analysis caused litigation?
It has, but again, everything gets appealed, even when it's strong. So.
All right. A lot of lawyers in this town.
Yeah.
So is it fair to say the bill won't really increase the amount of litigation, but actually might reduce it, do you think?
I don't know if it'll reduce it, but it could help make for better public policy.
Okay. Does the FCC itself often adopt requirements that contain undefined terms?
All the time.
Okay. Does leaving some terms in the bill undefined and allowing the FCC to define them provide flexibility to the agency?
It provides more certainty, and therefore, for future commissions, would limit the sort of arbitrary nature of whoever's in those chairs of interpreting more ambiguous terms.
Thank you. Doesn't the bill leave the public interest standard intact and still allow the FCC to deny transactions or impose tailored conditions such as divestitures of certain assets?
Yes, and actually, real briefly, I think it actually makes things more efficient in that regard. So if you're narrowing the scope of merger approval process and the substance of it, then you're actually, I think, speeding things up. That there are a lot of extraneous things then that could not be examined because it's not specific to the merger.
Okay. And lastly, is it your belief that there are sufficient bodies at the FCC that some could be spared to help implement this new law and that the improvement in policy would be well worth the effort?
I think the improvement would be well worth the effort.
Excellent. With that, I've got 50 seconds left. I don't want to get into a new line of questioning, so Mr. Chairman, I'll yield back. All right, if I want, do you want?
If you don't mind yielding to...
I'll yield to the esteemed
The gentleman yields.
So, Ms. McDowell, just in the final 40 seconds or so here, we didn't get time to really get into Chevron deference and what agencies can do, and the courts have a pattern of, say, deferring to what agencies have done if they've done their work, correct?
If they've done what was, I'm sorry?
Well, if they've followed their procedures and they've shown how they've complied, haven't courts also given Chevron deference to the FCC in matters?
Yeah, on procedure, but also on the substantive statutory language, if they're following that and are faithful to Congress's intent, yes.
Because I know, again, back to the Oregon examples with the Public Utility Commission, if you do your job, the courts will generally, isn't this true, Mr. Ramsey, defer to the expert agency?
Particularly on factual determination, yes, sir.
All right. My time, your time has expired. I'll let the chairman wrap it up.
The chairman or the gentleman's time has expired. And at this time, I defer to the chairman to see if there's any other further business to come before the committee.
I don't believe so. We want to thank our witnesses, though, for your expert testimony. It's very helpful. We realize we have a work product in front of us. What you've suggested will help us refine that product and get it right. And we will continue our efforts to reform this agency in a way that makes it a leader for the other agencies. Since we don't have full jurisdiction over the APA, we can only do what we can do, but we're going to do it. So thank you all. And
hearing no further business before the committee stands adjourned.